Everyone's patience, Madam President. We're working toward the end, which we're not there yet. I ask unanimous consent that it be in order for Senator Paul to offer 2 amendments en bloc and no other amendments be in order. Number 363, firearm records. Number 365, suspicious activity reports. There will be 60 minutes of debate prior to votes in relation to the amendments, with time equally divided between Senators Paul and the Majority Leader or their designees. That neither Paul amendment be divisible. Upon the use or reading back of the time, the Majority Leader or his designee be recognized for a motion to table. If there are not at least 60 votes in opposition to a motion to table, the above amendments be withdrawn. Further, upon disposition of the 2 Paul amendments, amendment number 348 be withdrawn. All remaining time post-closure be yielded back. The Senate proceed to vote on adoption of the motion to concur in the House Amendment to S990 with amendment number 347 that no points of order or motions be in order other than those listed in this agreement, and budget points of order and applicable motions to waive.
Madam President.
Senator from Vermont.
Madam President, reserving the right to object, I would ask consent that the agreement be modified to include the Leahy-Paul Amendment, SA 360, with the same time for debate and a vote under the usual procedures.
Is there objection?
Yeah, Madam President, I propounded this amendment, and I would just comment to my friend, the Chairman of the Judiciary Committee. This amendment that he has suggested has bipartisan support. And he's worked on this very hard. It's an amendment that we hope sometime the content of that amendment can be fully brought before the American people, because it is something that's bipartisan and timely. I would hope that we can get consent to include his amendment.
Madam President.
Minority Leader.
I object to the Leahy request.
Objection is heard.
Note the absence of quorum.
Is there any remaining objection to the request of the Leader?
Madam President, yes, you have some quorum.
Senator does not have the floor. Leader has the floor.
Note the absence of quorum.
Clerk will call the roll.
Mr. Akaka. Madam President, I renew my request.
Is there objection?
Madam President, reserving the right to object. I would first ask consent that an editorial, today's Washington Post, in favor of my amendment be included in the record at this point.
Without objection?
Madam President, again, further reserving the right to object. I find it extremely difficult that, and I have great respect for Senator Paul, who is, of course, co-sponsor of my amendment. But one more time, we have a case where we could have two amendments from the Republican side, and we have one that is co-sponsored by both Republicans and Democrats on this side. We can't go forward with it. We have two amendments that have not gone through any committee hearings. We have one on this side that's been voted by a bipartisan majority. Republicans and Democrats twice out of committee, twice on the floor, and that can't go forward. It is my inclination to object further, and I realize all the difficulty that I'd put my friend from Nevada in, and so I will not object, but I do feel this really ruins the chances to make the Patriot Act one that could have had far, far greater bipartisan support, and we have lost a wonderful chance, but I understand that we have to do what the Republicans want in this bill, and so I will withdraw my objection.
Is there objection? Without objection, so ordered.
Madam President,
Majority Leader.
this editorial to which the Chairman of the Judiciary Committee refers, 1, 2, 3, 4, very strong paragraphs indicating why his amendment is important and necessary. But in keeping with the kind of senator that we have, the senior senator from Vermont, the final paragraph is also quite meaningful. And it's meaningful because that's the kind of senator we have from Vermont by the name of Pat Leahy. It is at this late hour, this last paragraph, it is most important to ensure that the provisions do not lapse, which could happen as a result of a dispute between Senate Majority Leader Harry Reid and Senator Rand Paul of Kentucky over procedural issues. And here's the final sentence, and why Pat Leahy is a friend of the United States Senate and really is a legend in the Senate. If time runs out for consideration of the Leahy amendment, Mr. Leahy should offer a standalone bill later to make reporting requirements the law. So I appreciate very much Senator Leahy being his usual team player.
And Madam President, the Senator would yield just a moment. I referred to that last line that if this is not brought up, it should be offered as a freestanding bill. I assure the leader it will be offered as a freestanding bill, and I would hope that it is one, because of the bipartisan support of it, could be brought up at some point for a vote.
Madam President, this is an extremely important plateau we've reached. It's been very difficult for everyone. But now this bill can go to the President of the United States if these amendments are defeated, which I hope they are. Will be to the President tonight before the deadline of this bill. This bill will not lapse. And even though the Senator from Kentucky, Senator Paul, and I have had some differences, what we've done on this legislation is at least helped us understand each other, which I appreciate very much. And I appreciate his working with us on this. It's been most difficult for him and for me.
Who yields time?
Madam President.
Senator from Kentucky.
I'm pleased today to come to the floor of the Senate to talk about the Patriot Act. I'm pleased that we have cracked open the door, that we will shed some light on the Patriot Act. I wish the door were wider open, the debate broader and more significant, but we will talk a little bit about the constitutionality today of the Patriot Act. I was a co-sponsor of Senator Leahy's amendment, and I think it would have gone to many great steps forward to make sure that we have surveillance on what our government does. He would have authorized audits and the Inspector General to continue to watch over, to make sure that government is not invading the rights of private citizens, and I do support that wholeheartedly. Jefferson said that if we had a government of angels, we wouldn't have to care or be concerned about the power that we give to government. Unfortunately, sometimes we don't have angels in charge of our government. Sometimes we can even get a government in charge that would use the power of government in a malicious or malevolent way to look at the banking records of people they disagree with politically, to look at the religious practices of people they disagree with. So it's very important that we are always vigilant, that we are eternally vigilant of the powers of government, that they not grow to such an extent that government could be looking into our private affairs for nefarious reasons. We have proposed 2 amendments that we will have votes on today. One of them concerns the Second Amendment. I think it's very important that we protect the rights of gun owners in our country, not only for hunting but for self-protection, and that the records of those in our country who own guns should be secret. I don't think the government, well-intentioned or not well-intentioned, should be sifting through millions of records of gun owners. Why? There have been times, even in our history, when government has invaded your household to take things from you. In the 1930s, government came into your household and said, "Give us your gold." Gold was confiscated in this country in 1933. Could there conceivably be a time when government comes into your house and says, "We want your guns"? Well, people say that's absurd. That would never happen. I hope that day never comes. I'm not accusing anybody of being in favor of that, but I am worried about a government that is sifting through millions of records without asking, are you a suspect? Without asking, are you in league with foreign terrorists? Are you plotting violent overthrow of your government? By all means, if you are, let's look at your records. Let's put you in jail. Let's prosecute you. But let's not sift through hundreds of millions of gun records to find out whether or not you own a gun or not. Let's don't leave those data banks in the hands of government where someday those could be abused. What we're asking for are procedural protections. The Constitution gave us those protections. The Second Amendment gives you the right to keep and bear arms. The Fourth Amendment is equally important. It gives you the right to be free of unreasonable search. It gives you the right to say the government must have probable cause. There must be at least some suspicion that you are committing a crime before they come into your house or before they go into your records, wherever your records are. The Constitution doesn't say that you only have protection of records that are in your house. You should have protection of records that reside in other places. Just because your Visa record resides with a Visa company doesn't make it any less private. If you look at a person's Visa bill, you can find out all kinds of things about them. If you look at a person's Visa bill, you can find out what doctors they go to. Do they go to a psychiatrist? Do they have mental illness? What type of medications do they take? If you look at my Visa bill, you can tell what type of books I read, what type of magazines I read. One of the provisions of the Patriot Act is called the library provision. They can look at the books you check out in the library. Well, people say, well, still a judge has to sign these warrants, but we changed the standard. The standard of the Fourth Amendment was probable cause. They had to argue or at least convince a judge that you were a suspect, that you were doing something wrong. Now the cause or the standard has been changed to relevance. So it could be that you went to a party with someone who was from Palestine, who gives money to some group in Palestine that may well be a terrorist group or not. But the thing is, because I went to a party with them, because I know that person, am I now somehow connected enough to be relevant? And they would say, well, your government would never do that. They would never go and investigate people. The problem is this is all secret. So I don't know if I've been investigated. My Visa bills sometimes have been $5,000. Sometimes we pay for them over the phone, which is a wire transfer. Have I been investigated by my government? I don't know. It's secret. What I want are protections. I want to capture terrorists. Sure, if terrorists are moving machine guns and weapons in our country, international terrorists, by all means, let's go after them. But you know, the worst people, the people we want to lock up forever, the people all of us universally agree, people who commit murder, people who commit rape, we want to lock them up and throw away the book, and I'm all with you. But we still have the protections of the Fourth Amendment. If someone is running around in the streets of Washington tonight at 4 in the morning and we think they may have murdered someone, we will call a judge and we will get a warrant. Just because we believe in procedural protections, just because we believe in the Constitution, doesn't mean that we don't want to capture terrorists, but we just want to have some rules. I'll give you an analogy. Right now, you've been to the airport. Most of America has been to the airport at some point in time in the last year or two. Millions of people fly every day. But we're taking this shotgun approach. We think everyone's a terrorist. So everyone's being patted down. Everyone's being strip searched. We are putting our hands inside the pants of 6-year-old children. I mean, have we not gone so far? Are we so afraid that we're willing to give up all of our liberty in exchange for security? Franklin said, if you give up your liberty, you'll have neither. If you give up your liberty in exchange for security, you may well wind up with neither. Because we take this shotgun approach, we take this approach that everybody's a potential terrorist, I think we actually are doing less of a good job in capturing terrorists. Because if we spend our time going after those who are committing terrorism, maybe we'd spend less time on those who are living in this country, children and otherwise, frequent business travelers who are not a threat to our country. Instead of wasting time on these people, we could spend more time on those who would attack us. I'll give you an example. The underwear bomber. For goodness sake, his dad reported him. His dad called the U.S. Embassy and said, my son is a potential threat to your country. We did nothing. He was on a watch list. We still let him get on a plane. He'd been to Nigeria. He'd been to Yemen twice. For goodness sakes, why don't we take half of the people in the TSA who are patting down our children and let's have them look at the international flight manifest of those traveling from certain countries who could be attacking us. For goodness sakes, why don't we target who we're looking at? My other amendment concerns banking records. 8 million banking records have been looked at in our country. Not by the government. They've empowered your bank to spy on you. Every time you go into your bank is asked to spy on you. If you make a transaction more than $5,000, the bank is encouraged to report you. If the bank doesn't report you, they get a large fine to the tune of $100,000 or more. They could get 5 years in prison. They are over-encouraged. The incentive is for the bank to report everyone. So once upon a time, these suspicious activity reports were maybe 10,000 in a year. There are now over 1 million of these suspicious activity reports. Do I want to capture terrorists? Yes. Do I want to capture terrorists who are transferring large amounts of money? Yes. But you know what? When we're wasting time on 8 million transactions, the vast majority of these transactions being law-abiding U.S. citizens, we're not targeting the people who would attack us. Let's do police work. If there are terrorist groups in the Middle East and we know who they are, let's investigate them. If they have money in the U.S. or they're transferring it between banks, by all means, let's investigate them. But let's have some constitutional protections. Let's have some protections that say you must ask a judge for a warrant. Some have said, how would we get these people? How would we capture those who are transferring weapons? We would investigate. We have all kinds of tools, and we've been using these tools. Others have said, well, we've captured these people through the Patriot Act, and we never could have gotten them. The problem with that argument is it's unprovable. You can tell me that you've captured people through the Patriot Act, and I can believe you've captured them and you've prosecuted them, but you can't prove to me that you wouldn't have captured them had you not asked for a judge. We have a special court. It's called the FISA court. The FISA Court's been around since the late 1970s. Not one warrant was ever turned down before the Patriot Act. But they say we need more power. We need more power given to these agencies, and we don't need any constitutional restraint anymore. But my question is, the Fourth Amendment said you had to have a probable cause, you had to name the person and the place. Well, how do we change and get rid of probable cause and change it to a standard of relevance? How do we do that and amend the Constitution without actually amending the Constitution? These are important constitutional questions. But when the Patriot Act came up, we were so frightened by 9/11 that it just flew through here. There weren't enough copies to be read. There was one copy at the time. No senator read the Patriot Act. It didn't go through the standard procedure. And look at what's happening now. 10 years later, you'd think the fear and hysteria would have gotten to such a level that we could go through the committee process. Senator Leahy's bill went to committee. It was deliberated upon. It was discussed. It was debated. It was passed out with bipartisan support. It came to the floor with bipartisan support. But you know why it's not getting a vote now? Because they backed us up against the deadline. There have people who have implied in print that if I hold the Patriot Act up and they attack us tonight, that I'm responsible for the attack. There have been people who have implied that if some terrorist gets a gun, that I'm somehow responsible. It's sort of the analogy of saying that because I believe that you should get a warrant before you go into a potential or alleged murderer's house, that somehow I'm in favor of murder. I'm in favor of having constitutional protections. These arose out of hundreds of years of common law. They were codified in our Constitution because we were worried. We were incredibly concerned about what the king had done. We were concerned about what a far distant parliament was doing to us without our approval. We were concerned about what James Otis called writs of assistance. Writs of assistance were pieces of paper that were warrants that were written by soldiers. They were telling us we had to house the British soldiers in our house, and they were giving general warrants, which meant we're just going to search you willy-nilly. We're not going to name the person or place. We're not going to name the crime you're accused of. If a government were comprised of angels, we wouldn't need the Fourth Amendment. What I argue for here now is protections that protect us all should we get a despot, should we someday elect somebody who doesn't have respect for rights. We should obey rules and laws. Is this an isolated episode that we're here talking about the Patriot Act and that there's an insufficient time? It's a deadline, hurry, hurry, we must act. It's not an isolated time. We've had no sufficient debate on the war with Libya. We are now encountered in a war in Libya. So we now have a war in which there's been no congressional debate and no congressional vote. But you know what they argue? They say it's just a little war. But you know what? It's a big principle. It's the principle that we as a country elect people. It's a principle that we are restrained by the Constitution, that you are protected by the Constitution. And if I ask the young men and women here today to go to war and say we are going to go to war, that there darn well should be a debate in this body. We are abdicating those responsibilities. We are not debating the Patriot Act sufficiently. We're not having an open amendment process. Yes, am I pleased? It took me 3 days of sitting down here filibustering, but I'm going to get 2 amendment votes. I am very happy, and I am pleased that we came together to do that. I wish we would do more. I wish Senator Leahy's bill were being voted here on the floor. I wish there were a week's worth of debate. The thing is we come here to Washington expecting these grand debates. I've been here 4 months. But I expected that the important questions of the day would be debated back and forth. Instead, what happens so often is the votes are counted and recounted and laboriously counted. And when they know they can beat me or when they know they can beat somebody else, then they allow the vote to come to the floor. But some, like Senator Leahy's bill, I'm suspicious that it's not going to be voted on because we may not be able to beat it, or they may not be able to beat it. I support it. So the question is, should we have some more debate in our country? We have important things pressing on us. I've been here for 4 months, and I'm concerned about the future of our country because of the debt burden, because of this enormous debt we're accumulating. But are we debating it fully? Are we talking about ways we could come together, how Republicans and Democrats, right and left, could come together to figure out a crisis, this crisis of debt? No, I think we're so afraid of debate. But particularly with the Patriot Act, the thing is with the Patriot Act is that it's so emotional, because anyone who stands up like myself and says we need to have protections for our people, that we shouldn't sift through every gun owner in America through their records, looking and just trolling through records. Interestingly, we have looked at 28 million electronic records when the Inspector General looked at this. 28 million electronic records. We've looked at 1,600,000 texts. Now, if you said to me, well, they asked a judge and they thought these were terrorists, I don't have a problem. Judge gives them a warrant and they look at these text messages or electronic records. But do you want them trolling through your Facebook? Do you want them trolling through your emails? Do you want a government that is unrestrained by law? This ultimately boils down to whether we believe in the rule of law. So often we give lip service to it on our side and the other side, and everybody says, we believe in the Constitution and the rule of law. When you need to protect the rule of law is when it's most unpopular. When everybody tells you that you're unpatriotic or you're for terrorism because you believe in the Constitution, that's when it's most precious. That's when it is that you need to stand up and say, no, we can fight. We can preserve our freedoms. We are who we are because of our freedoms and our individual liberty. If we give that up, we're no different than those who we oppose. Those who wish to destroy our country want to see us dissolve from within. We dissolve from within when we give up our liberties. We need to stand up and be proud of the fact that in our country, it's none of your darn business what we're reading. It's none of your business where we go to the doctor or the movie or what our magazines are. It's nobody's business here in Washington what we're doing. If they think it's the business of law enforcement, get a warrant. Prove to somebody, at least have one step that says that person is doing something suspicious. The thing is these suspicious activity reports, 8 million of them have been filed in the last 8 years. The government doesn't have to ask for this. It's sort of like they have deputized the banks. The banks have now become sort of like police agencies. The banks are expected to know what is in the Bank Secrecy Act. They're expected to know thousands of pages of regulations. But you know what they tell your bank? If you don't report everybody, if you don't report these transactions, we'll fine you, we'll put you in jail, or we'll put you out of business. That is a problem. It is a real problem that that's what's come of this. And I think we need to have procedural protections. If at this point there was a request from the Senator of Illinois to yield for a question or for a comment, I'd be happy to if it's about the Patriot Act. Okay. The amendments that I will be proposing will be about two things, and we will have votes on them. We've been given the time to debate, which I'm glad we fought for. We will basically be given a virtually insurmountable hurdle. This will be maybe the first time in recent history I remember seeing this, but they will move to table my motions. In order for me to defeat the tabling motion, I'll have to get 60 votes. It is similar to the votes that we have when you have to overcome a cloture vote or you have to overcome a filibuster. But we really aren't having any vote where there's a possibility of me winning. There's really a foregone conclusion. The votes are counted in advance. I am proud of the fact that I fought for, though, and we got some debate on the floor, and that maybe in bringing this fight that the country will consider and reconsider the Patriot Act. But we need to have more debate. Senator Leahy's bill needs to be fully debated. It needs to come out. Maybe when there's not a deadline, maybe it will come forward. Maybe we can have some discussion. But I guess most of my message is that we shouldn't be fearful. We shouldn't be fearful of freedom. We shouldn't be fearful of individual liberty. And they're not mutually exclusive. You don't have to give up your liberty to catch criminals. You can catch criminals and terrorists and protect your liberty at the same time. There is a balancing act. But what we did in our hysteria after 9/11 was we didn't do any kind of balancing act. We just said, come and get it. Here's our freedom. Come and get it. We don't care whether there's review in Congress. We don't care whether there is to be an inspector general looking at this. One of my colleagues today reported, well, there's no evidence those 8 million banking investigations are bothering or doing anything to innocent people. Well, there's a reason for there being no evidence. They're secret. You're not told if your bank has been spying on you. If your bank has put in a suspicious activity report, you're not informed of that. So the bottom line is, just because there's no complaint doesn't mean there haven't been abuses. There's something called national security letters. These are written by officers of the law, by FBI agents. There's no review by judges. There have been 200,000 of these. There's been an explosion of these national security letters, and we don't know whether they're being abused because they're secret. In fact, here's how if the government came to you with an FBI agent's request, you could not even tell your lawyer. This, I think, is very disturbing. They finally got around to changing that. But you know what? If I have an internet service, if I'm a server and they come to me with a policeman's request and they say, give us your records, if I tell anyone other than my attorney, I can go to jail for 5 years. What we have is a veil of secrecy, so even if the government is abusing the powers, we will never know. Madam President, can you tell me how we're doing on our time, please?
Senator has 8 minutes remaining.
Okay. Did the senator from Illinois wish to interject?
Understand that there's time on the other side as well.
28 minutes on the majority.
I would like to.
You're welcome to interject now or at a later time.
I'd like to speak on the majority side.
Okay.
Senator, yield the floor.
I'll go ahead and finish up then. As we go forward on these, I would hope that there would be some deliberation and that the vote as it goes forward, people will think about that we need to balance our freedoms with our security. I think we all want security. Nobody wants what happened on 9/11 to happen again. But I think we don't need to simplify the debate to such an extent that we simply say we have to give up our liberties. For example, I can't tell you how many times people have come up to me in Washington, other elected officials, and they say, we could have gotten Moussaoui, the 19th hijacker, if we'd had the Patriot Act. The truth of the matter is that we didn't capture Moussaoui because we had poor police work. And ask yourself, did we fire anybody after 9/11? We gave people gold medals. We gave them medals of honor for their intelligent work after 9/11. To my knowledge, not one person was fired. Do you think we were doing a good job before 9/11? We had the 19th hijacker in prison or in custody for a month before 9/11. We had his computer. When they looked at Moussaoui's computer 4 days after 9/11 or the day after 9/11, they connected all the dots to most of the hijackers and to people in Pakistan. Why didn't we look at his computer? Was it because we didn't have the prerogative? They didn't ask. An FBI agent in Minnesota wrote 70 letters to his superior saying, ask for a warrant. His superiors didn't ask for a warrant. Do you think we should have done something about that after 9/11? We gave everybody in the FBI and the CIA medals. We gave the leaders medals for meritorious service, and no one blinked an eye. What did we do? We passed the Patriot Act and said, come and take our liberties, make us safe. But to make us safe, we shouldn't give up our rights to protect what we read, to protect what we view, to protect where we go and who we associate. We shouldn't allow government to troll willy-nilly through millions of records. You've heard of warrantless wiretaps. A lot of these things are unknown because they're so secret that nobody knows. Even many of us don't even know the extent of these things. But I can tell you that there is a great deal of evidence that we are looking at millions of records and that millions of innocent U.S. citizens are having their records looked at. Now, are we doing anything? Are we imprisoning innocent folks? No, I don't think we're doing that. I think they're good people. I think the people I've met with the FBI, the people I've met in our government, they want to do the right things. But what I am fearful of is that there comes a time when you've given these powers up. You know, when you recognize, for example, the constitutional discussion over war, if you say, well, Libya is just a small war, we don't care, and you say that Congress has no say in this, what happens when we get a president who decides to send 1 million troops into war and we simply say, who cares? You know, we let the president do whatever he is because he's got unlimited powers. You know, we fought a war. We fought long and hard to restrict. We wanted an executive that was bound by the chains of the Constitution. We wanted a presidency, an executive branch that was bound by the checks and balances. That's what our Constitution's about. It is about debate. Debate is important. Amendments are important. Bringing forward something from committee that would have reformed the Patriot Act is incredibly important, to have those debates on the floor. And that's why there is a certain amount of disappointment to having arrived in Washington and to see the fear of debate of the Constitution, and that we really need to be debating these things. We need to have full amendments. We need to, can there be any excuse why the Inspector General should not be reviewing other agencies of government to find out if your rights are being trampled upon? So I would ask in conclusion that as these amendments come forward, that people think about it, think about our constitutional protections, but don't go out and say that, you know, the senator from Kentucky doesn't want to capture terrorists, or that the senator of Kentucky wants people to have guns and to attack us. Because the thing is we can have reasonable philosophic debates about this, but we need to be having an open debate process. We need to talk about the constitutional protections, the protections that protect us all, and we need to be aware of that. I tell people you can't protect the Second Amendment if you don't believe in the Fourth Amendment. You can't protect the Second Amendment if you don't believe in the First Amendment. It's all incredibly important, and I hope as we go forward on this vote, and even though I will likely fail because of the way the rules are set up on the vote, I hope as we go forward that at least somebody will begin to discuss this. Somebody will begin to discuss where we should have some constitutional restraint. That Senator Leahy will have a chance to bring his bill forward, that there will be a full and open debate, and I hope that we've cracked the door open, that I've been a small part of that. Thank you, Madam President, and I yield back my time.
Madam President.
The senator from Illinois is recognized.
Madam President, it's my understanding that we have a consent that will allow Senator Paul to offer 2 amendments, and then we'll go to final passage on this reauthorization of the Patriot Act.
That's correct.
Madam President, I will oppose the amendments offered by Senator Paul and then oppose the reauthorization of the Patriot Act, and I'd like to explain in my remarks why. I voted for the Patriot Act in the year 2001. In fact, there was only one senator on the floor, who no longer serves, who voted against it. It was a moment of national crisis. We were told then by the Bush administration they needed new authorities to make certain that America would be safe and never attacked again. And I want to salute Senator Patrick Leahy, as well as his counterparts on both sides of the aisle, who really worked night and day to put together a bipartisan version of this Patriot Act and had the good sense to include in it a sunset. We knew that we were writing a law with high emotion over what had happened to our country. We wanted to make sure it was a good law, but we made certain that it would be temporary in nature for the most part, and we would return and take another look at it. I cannot vote for an extension, a long-term extension of the Patriot Act without additional protections included for the constitutional rights of our American citizenry. It's worth taking a moment to review the history. The Patriot Act was passed 10 years ago, almost 10 years ago, while Ground Zero was still burning. Congress responded and passed it with an overwhelming bipartisan vote. It was a unique moment in our history. But even then, we were concerned enough to put a sunset and to do our best to review it in the future to determine whether it went too far when it came to our freedoms. I voted for it, but I soon realized that it gave too much power to government without enough judicial and congressional oversight. So 2 years after the Patriot Act became law, I joined a bipartisan group of senators in introducing the SAFE Act, legislation to reform the Patriot Act. The SAFE Act was supported by advocates from left and right, from the ACLU to the American Conservative Union. Progressive Democrats and very conservative Republicans came together across the partisan divide, understanding Americans can be both safe and free. We wanted to retain the expanded powers of the Patriot Act, but place some reasonable limit to protect constitutional rights. When he joined the Senate in 2005, Senator Barack Obama became a co-sponsor of our SAFE Act. Here's what he said, and I quote, "As a senator, we don't have to settle for a Patriot Act that sacrifices our liberties or our safety. We can have one that secures both." I agree with then Senator Obama. In 2006, the first time Congress reauthorized the Patriot Act, some reforms from the SAFE Act were included in the bill, and I supported it. However, many key protections from the SAFE Act were not included, so there are still significant problems. The FBI is still permitted to obtain a John Doe roving wiretap that does not identify the person or the phone that will be wiretapped. In other words, the FBI can obtain a wiretap without telling a court who they want to wiretap or where they want to wiretap. In garden variety criminal cases, the FBI is still permitted to conduct sneak and peek searches of a home without notifying the homeowner about the search until later time. We now know that the vast majority of sneak and peek searches take place in cases that don't involve terrorism in any way. A National Security Letter, or NSL, is a form of administrative subpoena issued by the FBI. We often hear NSLs compared to grand jury subpoenas. But unlike a grand jury subpoena, a National Security Letter is issued without the approval of a grand jury or even a prosecutor. And unlike the grand jury subpoena, the recipient of an NSL is subjected to a gag order at the FBI's discretion. The Patriot Act also greatly expanded the FBI's authority to issue NSLs. An NSL now allows the FBI to obtain sensitive, personal information about innocent American citizens, including library records, medical records, gun records, and phone records, even when there's no connection whatsoever to a suspected terrorist or spy. The Justice Department's Inspector General concluded that this standard, quote, can be easily satisfied, close quote. This could lead government fishing expeditions that target innocent people. For years, we've been told there's no reason to be concerned about this broad grant of power to the FBI. In 2003, then Attorney General Ashcroft testified to our committee that librarians raising concerns about the Patriot Act were, quote, hysterics, and that, quote, the Department of Justice has neither the staffing, the time, nor the inclination to monitor the reading habits of Americans. But we now know the FBI has, in fact, issued national security letters for the library records of innocent people. For years, we were told the FBI was not abusing this broad grant of power, but in 2007, the Justice Department's own Inspector General has concluded the FBI was guilty of, quote, widespread and serious misuse, close quote, of the National Security Letter Authority and failed to report these abuses to Congress and the White House. The Inspector General reported that the number of National Security Letter requests has increased exponentially from about 8,500 the year before enactment of the Patriot Act to an average of more than 47,000 per year, and that even these numbers were significantly understated. Madam President, we can be safe and free. I think it's important that the measure that passed the Senate Judiciary Committee should have been on the floor. It included an amendment which I offered with Senator Lee and other provisions which I think are an improvement over the current bill before us. I'll say one quick word about the amendment by Senator Paul. I don't believe it is in our nation's best interest to exempt gun records from terrorist investigation. For goodness sakes, when we are dealing with people, terrorists, using guns, searching the records to make certain that we know the source of those guns and whether or not there are any other threats to this nation is a reasonable thing to do. These should not be so sacred and sacrosanct that we don't ask the hard questions when our nation's security is at risk. I would agree with him that we ought to make certain there is a connection between that request for gun record information and a suspected terrorist or spy. But to say that these records cannot be asked for under the Patriot Act, I think goes too far, and that's why I will oppose his amendment. Madam President, I yield the floor.
Madam President.
The senator from Georgia is recognized.
Madam President, I rise to speak in opposition to Amendment Number 365, Senator Paul's amendment concerning suspicious activity reports, or what's referred to as SARS. This amendment would prevent the Department of Treasury from requiring any financial institution to submit a suspicious activity report unless law enforcement first requests the report. If this amendment should become law, it will effectively take away one of the government's main weapons in the battle against money laundering and other financial crimes. It will also negatively impact our efforts to detect and follow the flow of funds to and from international terrorists. It's important to remember that SARs are essentially tips from third-party financial institutions concerning suspicious transactions. Because law enforcement is not watching the financial transaction of every American on a daily basis, 24/7, they often have no idea that a person is even engaged in a financial crime until they receive a suspicious activity notification from a financial institution. In a sense, SARs are not much different than the tips that law enforcement often receives from anonymous sources. These tips or leads can often form the basis for initiating investigations that can be used to neutralize criminal or terrorist activities. The problem with this amendment is it would require the government to look into a crystal ball in order to figure out when they should request a SAR. With this logic, we should only allow law enforcement to act on an anonymous tip unless they ask for the tip to be reported first. If a law enforcement or intelligence official doesn't get a tip about suspicious activity, how in the world are they going to know when it has occurred in the first place? The answer here is pretty simple. They will likely never know that it occurred until the criminal activity has occurred, and maybe even it will go undetected. Let's look, for example, about the 9/11 hijackers. There were a minimum of 12 to 13 of those individuals who came into and out of the United States over a period of time. Money was transferred to and from those individuals over a period of time. Under the requirements pre-Patriot Act, there was no suspicious activity detected. But after the enactment of the Patriot Act, there would be reason now for any financial institution to suspect the potential for suspicious activity from those transfers of monies. That's exactly why we did what we did in the Patriot Act, and that's one of the reasons why we have not seen a subsequent direct attack on U.S. soil from individuals who have been in the United States and have received money through transfers or whatever it may be. And let's don't forget that Section 215 business records cannot be obtained in an arbitrary manner. There has to be, first of all, a determination that there is some international connection between the individual whose account has been deemed suspicious by the financial institution, and also there has to be some follow-on procedure to determine that there is reason for the government to get a hold of the financial records of this individual. In my mind, this amendment would put law enforcement in an unacceptable and unreasonable position. At the same time, we're asking them to pursue swindlers and money launderers more aggressively. We need to preserve the requirement that financial institutions report suspicious activities. We need to follow up on these leads, not just from a criminal law enforcement perspective, but from a national security perspective as well. And let me just say that since 9/11, I have been involved with the Intelligence Committee all of those years. We do extensive oversight on this particular provision in the Patriot Act as well as other provisions. And we have hearings on this from time to time, and we require the law enforcement officials to come in and talk to us about what they're doing. And to my knowledge, there has never been one complaint or abuse that's been shown from the use of this particular provision. So, Madam Chairman, Madam President, this particular provision is working exactly the way that we intended it to work, and it's a valuable tool for our law enforcement. Let me speak also about Amendment number 363, which is Senator Paul's amendment concerning firearms records. Simply put, this amendment would make it more difficult for national security investigators to prevent an act of terrorism inside the United States. The amendment would prohibit the use of a FISA business records court order to obtain firearms records in the possession of a licensed firearms importer, manufacturer, or dealer. Instead, national security investigators could only obtain such records through a federal grand jury subpoena during the course of a criminal investigation or with a search warrant issued by a federal magistrate upon a showing of a reasonable cause to believe that a violation of federal firearms laws has occurred. That might not always be possible. For example, before Major Nidal Hassan began his deadly assault against innocent military and civilian personnel in Fort Hood, Texas in November of 2009, there was no evidence that he had violated any criminal or federal firearms laws. Thus, the Federal Bureau of Investigation could not have relied on Title 18 to obtain information about Hassan's purchase of the firearms used in the attack. As we have since learned, however, there was likely enough intelligence information to open a preliminary investigation on Hassan because of his contacts with a known al-Qaeda member in Yemen and seek a Section 215 order for information about his gun purchases. I don't understand why we would take this tool away from national security investigators, especially here again where there has been no indication of any abuse of this authority with respect to firearms or other sensitive records. Congress has conducted extensive oversight of the Patriot and FISA authorities, and there have been no reports of any widespread abuse or misuse and no reports that the government has ever used these authorities to violate Second Amendment rights. Moreover, the protections detailed in Section 215 ensure that Second Amendment rights are fully respected in the use of this authority. Unlike in criminal investigations where a federal grand jury may issue a subpoena for firearms records, any request for records under Section 215 must first be approved by the Foreign Intelligence Surveillance Court. As with all other Section 215 records, the court must find that such records are relevant to an authorized national security investigation. This means that the FBI cannot use this authority in a domestic terrorism investigation, nor can the FBI randomly decide to see whether an ordinary citizen or even a vocal advocate of the Second Amendment owns a firearm. There are two additional oversight safeguards that are built into the Section 215 process. First, each request for sensitive records by the FBI can only be approved by one of three high-level FBI officials: the director, the deputy director, or the executive assistant director for national security. Second, there are also specific reporting requirements that are designed to keep Congress informed about the number of orders issued for these types of sensitive records. One of the big lessons we learned after the 9/11 terrorist attacks was that we needed to make sure that national security investigators had access to investigative tools similar to those that have long been available to law enforcement. Section 215 of the Patriot Act addresses that need. It provides an alternative way to obtain business records, including firearms records, in situations where there may be a national security threat, but not yet a criminal investigation or violation. Now, I have been a strong supporter of the Second Amendment. There's nobody in this body that has a better voting record on the Second Amendment than I do. Probably nobody here owns as many guns as I own, but I use them for legal and lawful purposes. And I'll work with the National Rifle Association and any citizen group to make sure that neither this law nor any federal law is misused to infringe on Second Amendment rights of any law-abiding citizen. But this particular amendment would harm legitimate national security investigations. Madam President, I'd like to take 1 minute to read a letter that I've received from Chris Cox, who is the Executive Director of the National Rifle Association. Dear Senator Chambliss, thank you for asking about the National Rifle Association's position on a motion to table Amendment 363 to the Patriot Act. The NRA takes a backseat to no one when it comes to protecting gun owners' rights against government abuse. Over the past 3 decades, we fought successfully to block unnecessary and intrusive compilation of firearms-related records by several federal agencies, and will continue to protect the privacy of our members and all American gun owners. While well-intentioned, the language of this amendment as currently drafted raises potential problems for gun owners, in that it encourages the government to use provisions in current law that allow access to firearms records without reasonable cause, warrant, or judicial oversight of any kind. Based on these concerns and the fact that NRA does not ordinarily take positions on procedural votes, we have no position on a motion to table amendment number 363. So, Madam President, for those reasons, I intend to vote against both these two amendments, and while I appreciate the intent and the emotion with which my friend Senator Paul comes to this floor to advocate, we need to make sure that we get these extensions in place immediately so that we have no gap in the coverage available to our intelligence community and that we continue to give them the tools they need to protect America and to protect Americans.
Madam President.
Thank you. Senator from Delaware is recognized.
Madam President, I ask unanimous consent that the Senate proceed to S-1114, a short-term, one-month Patriot Sunset Extension bill, which is currently at the desk, that the bill be read 3 times and passed, that the motion to reconsider be laid upon the table with no intervening action or debate.
Is there an objection? Objection is heard.
Madam President, I am disappointed that my unanimous consent request was not agreed to. And I'd like to explain my action here today, and the comments that I'm about to give are an explanation of a vote I intend to take later today. As Senator Chambliss said just before me, the powers of the Patriot Act are too important for us to risk their expiration as this body considers whether or not to amend them or revise them, and I couldn't agree more. So I offered a one-month extension in order that this body might take the time that I think is so needed and so deserved to seriously debate and conduct real oversight over the Patriot Act. This is a significant piece of national security legislation that I believe is worthy of further consideration and debate. Law enforcement agencies, state, federal, and local work day in and day out, as we know, to protect us from very real threats that go largely unknown by most Americans. And I want law enforcement to have all appropriate tools in their toolbox to accomplish this goal. Unfortunately, there are also, in my view, legitimate concerns about the legislation on which we are about to vote, concerns that my colleagues and I, including yourself, Madam President, on the Judiciary Committee, reviewed and addressed in detail, and in a bill ultimately passed, S-193, which forms the core of the Leahy-Paul Amendment, of which I am a co-sponsor, we put those modest, real, but needed revisions to this Act before this Chamber. Madam President, I'm disappointed we don't have consent to move forward in order to have time to debate these reforms to the Patriot Act. As Americans, the choice between liberty and safety is not one or the other. We expect and demand both. Balancing the two responsibly requires careful consideration to each. We must be cognizant our nation's very real enemies intend to do us harm, just as they did on September 11th. It was awareness of the dangers of the world that motivated this Congress, as we've just heard in the previous speeches, to enact the Patriot Act now nearly 10 years ago in the wake of those attacks. A grave new threat called for bold new authorities. Though I was not then in the Senate, I likely too would have voted for its passage. But this body's passage of the Patriot Act did not amount to a permanent choice of security over liberty. Because of the broad scope of the new authorities in the Patriot Act, the bipartisan drafters of the bill insisted upon placing key sunset provisions in the bill to ensure that Congress periodically reviewed how they were being used and assessed whether they were still essential to our security. Madam President, being cognizant of the number of other members who hope to speak on this topic today, I ask unanimous consent that the body of my comments be entered into the record in order that I might summarize and proceed to a conclusion.
Without objection, so ordered.
If I might, in summation, simply say this. If we were today to pass a 4-year extension without amendment, without revision, it will have been 9 years in which Congress does not act in any substantive way on the amendments. I join the chairman of the Judiciary Committee, Senator Leahy, in intending to vote no today, not because I believe the Patriot Act is fundamentally flawed, not because I believe the United States doesn't face real enemies, but because I think this Congress has not taken seriously its very real oversight responsibilities, its need to strike that balance. The Judiciary Committee did that hard work, and for this Congress to not amend this bill with the simple, balanced, and reasonable amendments offered in the Leahy-Paul amendment, I believe I am compelled to strike the balance between security and liberty on the side of liberty today by saying that this body has failed to act and to appropriately conduct thorough oversight of this bill before we send it 4 years into the future. With that, Madam President, I yield the floor.
Madam President.
Senator from Michigan is
Madam President, how much time is left on the majority side?
Looks like 5.5 minutes.
I thank the presiding officer. Madam President, I rise in opposition of the amendment of Senator Paul, Amendment Number 365. This amendment would effectively wipe out a critical tool that is used against terrorists, against drug traffickers, and I want to explain exactly what these suspicious activity reports are and why they're so essential to the FBI and to other law enforcement people. First of all, who uses them? FBI, organized crime units, drug trafficking task forces, border security, Secret Service, state and local police, intelligence community all use these SARs. Secondly, what are they used for? There was a report from the 2009 GAO, a report in that year, which said the following. How are SARs used? They gave a number of examples. The FBI includes SAR data in its investigative data warehouse to identify, quote, financial patterns associated with money laundering, bank fraud, and other aberrant financial activities. Secondly, Organized Crime Drug Enforcement Task Force Fusion Center combines SAR data with other data, quote, to produce comprehensive integrated intelligence products and charts. Third, the IRS uses SARs to identify, quote, financial crimes, including individual and corporate tax frauds and terrorist activities. We received a letter just today from the Attorney General of the United States strongly opposing this amendment of Senator Paul. And this is what the Attorney General says. SARs are a critical tool for our national security and law enforcement professionals. SARs are used to alert intelligence and law enforcement personnel to issues that warrant further investigation and scrutiny. The purpose of the SAR regime is to require financial institutions to report on suspicious activities based on information, and this is the key point, that is solely within their possession. Prior to the filing of a SAR, the Attorney General said, our law enforcement and intelligence analysts often are not aware that a particular bank account or individual may be associated with criminal activity or may be engaged in activities that pose a threat to national security, such as the funding of terrorist activities. And then the Attorney General goes on, conditioning the filing of SARs upon a request from law enforcement would undermine this purpose. By definition, he said, SARs are designed to alert law enforcement to information not otherwise within its possession. The Paul Amendment number 365 is very short, but what it does is say that you must have a request of an appropriate law enforcement agency for the report before there's a requirement to file a suspicious activity report. And as the Attorney General points out in a letter that I'd ask unanimous consent, Madam President, be inserted in the record at this point.
Without objection, so ordered.
That would totally undermine the purpose of